Good afternoon.
Good afternoon, Your Honor.
Good. Good.
Good afternoon.
Good afternoon.
Okay, you guys can hear me. Alrighty. Okay. Nelson's, if you would go ahead and probably turn your phone to so it be landscape so I can see, or turn your device so I can see the both of you.
All right, hang on just 1 second. Let me auto rotate.
All right, let's go ahead. Is anything preliminary that we need to go ahead and discuss off the record before we get started?
Your Honor, I haven't heard from any attorney from the Nelsons, and I just want to make the court aware. I don't know if they have one or not, but I haven't been able to contact one.
All righty.
Not in contact with her.
Okay, well, we'll be able to go ahead and put that on the record. There being nothing else at this time, good afternoon. And we're going to go ahead and get on record on cause number 2022 CV01009. And this is a matter of Peter Barateche, plaintiff versus Chris Nelson and all other occupants as defendants. Parties, please approach and identify who is before the court, starting with the plaintiff.
Amanda Ornelas with Pullman Capuccio and Pullen, attorneys for the plaintiff, Your Honor. Peter Baratachea.
Peter Baratachea, Your Honor. Here.
Nelson?
Oh,
Yes, Christopher Nelson, I'm here.
and Tara Goldsby.
I'm sorry, say that name again.
It's Tara Goldsby.
Okay, alrighty. Please go ahead and state the first name, spell it, state the second name and spell it.
Mine,
Yes, ma'am, yours.
it's Tara. It's T as in Tom, A as in apple, R as in rabbit, and A as in apple. And then the last name is Goldsby. And that is G-O, L as in Larry, D as in dog, S as in Sam, B as in boy, and Y as yellow.
Okay, thank you very much. And I understand that this matter, I believe, was originally set at, let me see, on the 19th of May, 2022. We at that time reset it for Friday, the 27th of May, 2022. However, the court had indicated that the court would call you to let you know the time, and court was not able to go ahead and do that in a timely fashion. And you all agreed to reset it to today, the 3rd of June, 2022 at 6:30, and that is where we are. You all agreed to this day and time. Is that correct? Is that your understanding, Attorney Ornelas?
Other than the time, it was 4:30 rather than 6:30, but the rest of that is correct.
Oh, I'm so sorry. I may have said 16:30, which is a 24-hour clock, but it's 4:30 p.m. actually. Alrighty, and so, and at the time of the reset on the initial for the 27th of May, I believe the Nelsons, you had indicated at that time that you had an attorney or needed time to make sure that your attorney was here. But what the court has recalled so far, stated so far as the resettings, is that your understanding?
Yes. And she
Okay.
was supposed to get a hold of the other attorney.
Now we're here. We have reset this matter 2 times. We're here, and we are here for a non-jury trial. Is that what
Yes,
we're
Your Honor.
here for? Okay. And you had announced approximately 20 minutes for this matter, correct?
Yes, Your Honor.
Alrighty. Now, Mr. Nelson, this matter is styled Chris Nelson et al. You have, you're Christopher Nelson, correct? Or Chris Nelson?
Correct.
Alrighty, and you say your name is Goldsby?
Yes, that's my last name.
Okay, and so are you part of the et al. Or other occupants?
Yes, because I live with Christopher Nelson. He's my husband.
Okay, alrighty. So now you had indicated to this court that you thought that you had or gave the court the impression that you had an attorney by the name of Carol, but you did not have a last name for Carol from the Texas Rio Grande Legal Aid.
Yes, it was like her last name it started with an A. I can't remember what it is now.
Well, ma'am, you've had since the 19th of May to be able to determine that, correct? Or at least the 27th of May.
Yes, I just couldn't remember what her last name fully was. I know it starts with an A.
Alrighty. I'm sorry, say again?
We've been in contact with her since then. She's supposed to be here right now.
Yeah.
Oh, you have been in contact with her?
Yes, I've been in contact with her and she was supposed to be here today. And I even talked to her this morning.
Okay. I'm more than willing to go ahead and suspend the record for a minute for you guys to try to contact her and see if she will join us. But it's only going to be for a minute or two if you'd like to try and contact her.
Okay, I'll try and get in contact with her real quick.
All righty.
All right, thank you.
All right. Mr. Nelson? Hello? Mr. Nelson, Ms. Goldsby? I'm sorry, I was just figuring out a notation. Do you know what, do you have any indication of what's going on at that council? Oh, okay, all righty. Ms. Goldsby? Mr. Nelson?
Hang on one second. Just got to get the screen back up. Sorry.
Okay.
I was trying to call her and her last name is Ajero. Open up, come on. All right. I just tried to call her 3 different times. Are you there?
Yes, I am. I'm
Okay,
listening.
okay,
Yes.
okay. I wasn't sure if you were hearing us or not.
Sure, absolutely hearing you. If you will go ahead and adjust so that I'll be able to see the both of you. Okay, so you have not been able to go ahead and reach her.
No, I just tried to call her 3 times.
All righty. And you had provided this court also let's get back on record on cause numbers 2022 CV 01009. In the matter of Peter Barateche, plaintiff versus Chris Nelson and all other occupants or et al. At the time that we suspended the record, I gave the defendants an opportunity to call to see about an attorney by the name of Carol. The defendants do not know the last name of the attorney that the indicated works for Texas Rio Grande Legal Aid. And in just full disclosure, out of concern, this court did call the Texas Rio Grande, just so that you know, in full disclosure, to inquire and see if I may be able to facilitate. However, because of their confidentiality policies there, I was only able to leave a message with all the information concerning the court setting. And so and I provided them their number to you to see if they could get a hold of you and be able to give you direction. So Mr. Nelson or Ms. Goldsby, were you contacted by the Texas Rio Grande Legal Aid this afternoon?
This afternoon, no, I wasn't contacted by them.
Okay. They had indicated that they would check and see if you were actually had contact with them or if you were part of the file, but they could neither confirm nor deny whether that you were, they had you on their caseload. So at this time, what do you wish to do as you do not have this Carol? And I've given you the opportunity to contact her. What do you wish to do? Do you have any requests to the court at this time?
I would like to be able to have an attorney present. Do we have to get another attorney or something? Because I don't know what's going on with this attorney. We can contact her and we talk to her, And then when it comes time to go to court, she's nowhere to be found. I don't know what's going on with this.
I mean, if we need to get another lawyer, I'll definitely find a different lawyer because I don't understand why it's so difficult for one to show up to court.
Okay. Anything else?
Not that I can think of right now.
Okay. Plaintiff?
Your Honor, also, because we would like to disclose to the court as well, we did give Texas Rio Grande Legal Aid a call as well. I was also told of the confidentiality process that they have. And so they were also not able to confirm or deny whether Mr. Nelson was one of their clients, but they did tell me that there was not an attorney named Carol working in the department that would handle this. So I'm not sure that they're speaking with Texas Rio Grande Legal Aid or if they're speaking with possibly a legal assistant. And so we would ask to move forward in this case just because my client has, given them many opportunities to contact an attorney. They did have an attorney at one point that withdrew, and this has been going on since November. And so we'd really like to move forward with this.
November of what?
2021.
And just for record purposes, the number I called for Texas Rio Grande was area code 956-996-8752. You provided that number, correct, Mr. Nelson?
Yes.
Yes.
Okay, and so that's the number that I called. Counselor, was that the number that you called as well?
I don't remember exactly the number, but we also called the number that was provided by Mr. Nelson on the May 19th hearing.
Okay, all righty. So, counsel, your argument is for the court to deny the motion, a motion for continuance as the Nelsons have put it. You are
Yes, Your Honor.
asking to continue, just to make sure, Mr. and Mrs. Nelson, or Chris Nelson and Ms. Goldsby, you're asking for the court to continue this matter for you to acquire an attorney.
Yes, we would like to acquire an attorney
A better one, that's
or
for sure.
a better one, or one that's, somebody that's going to represent us.
And how do you intend to do that? Is it still going to be through the Texas Rio Grande Legal Aid? Do you intend to hire an attorney?
Whichever manner we have to go through. If we have to hire one, we'll hire one. It's just a matter of, we're not from Texas, so we have to just try and find out which lawyers are available for eviction. And I know that's just a matter of doing, my Google search real quick and then being able to get one.
But did you not have an attorney by the name of David Schaefer on this case?
Yes, we did have an attorney that was by the name of David Schaefer at the very beginning.
Okay.
And actually, he was the one that contacted us. We didn't even contact him.
Okay, you mean that he sent an advertisement to you?
Yeah, he was the one that sent an advertisement to us.
And then you took that advertisement and you contacted him?
Yeah,
You followed up?
Yeah, not that he called us, no.
Okay, all righty. Okay. Plaintiff?
Yes, Your Honor.
Any response to the defendant's comments here?
Your Honor, I feel like they've been given multiple opportunities to contact an attorney. They have a pattern of overpromising and under-delivering when it comes to this court, as well as the Windcrest Municipal Court that we've had a hearing in as well. And so, again, we just asked to move forward in this case.
Counsel, would you like to make record of, proffer for the record exactly why this case is such at a point where it needs to be moved on when you have pro se litigants who are asking for the court to give them consideration to have an attorney present to represent them?
Your Honor, my client, he owns a house in Windcrest. It's the property in question here today. And the city of Windcrest has been pushing our client as well as the Nelsons to get this resolved, as there are pending citations regarding the property that Mr. Baratachea is not allowed to go and remedy at this time because he doesn't have possession of the premises. And so while this is pending, the municipal court is waiting on this this case to be resolved so that their case may be resolved as well.
And what is the plaintiff asking for today? Or what
Honor,
would be the nature of the plaintiff's request?
Your Honor, we're asking for this court to dismiss this appeal from the JP court. We're also asking for a writ of possession for the property, and we're asking for attorney's fees.
Attorney's fees?
Yes, Your Honor.
When you say you wish a writ of possession, what does that mean? And when will that, what would happen? What would be the procedure for that, or the process for that?
So, Your Honor, under Texas Rule of Procedure 510.13, we're asking the court to issue a writ of possession within 10 days from the date of this judgment, allowing the Nelsons to remove themselves from the property. That way, Mr. Baratachea can regain possession of the premises.
And what is that code that you cited from what statute?
It's Texas Rule of Procedure 510.13, Your Honor.
And you said within 10 days, it's to issue, to grant a writ of possession. Within that 10 days, what happens? Is that time for you to provide an order to the court, or would that be time for the defendants to vacate?
The statute provides that the writ of possession may not be issued until 10 days after the court's judgment. And so that's just the amount of time that's allotted. If the Nelsons are to leave, if they do leave before the 10 days has expired, then a writ of possession wouldn't be needed. But we're asking the court for, in my proposed order that I can send to the court, I'm asking for a writ of possession. That way the court is authorized to issue one in 10 days from the date of the judgment if the Nelsons do not vacate.
And when you talk about a writ of possession, what does that mean, let's just say in ordinary language?
Just means that the court can issue this writ allowing the police to post a notice on the resident's door, letting the defendants know that they have a certain amount of days to remove themselves from the premises, or the police would go in, remove all the belongings and leave them on the curb.
And what is the effect of that?
Actually,
As
it
far
just-
as the defendants are concerned?
Essentially, it just says there's a court order that you need to, you've been evicted from this residence, and if you do not leave, the police will remove you from the residence.
So they would end up with an eviction on their record?
So if the court grants judgment for the plaintiff today, they will have an eviction on their record regardless. But if they do not leave within 10 days, then the police will have to enforce the judgment with the writ of possession.
Do you know what the effect or consequences of having an eviction on the record? What does that? What happens?
If they have an eviction on their record, Your Honor, I believe that in the future, when they apply for other apartments or rental units, it will be shown when they run a check on them.
Is there a method or a way to be able to avoid having that eviction on the record at this point?
Not that I'm aware of, Your Honor. And we've tried to avoid this by not having a hearing, by not having to go through with this and asking them to leave the property so we can avoid any sort of eviction on their record. But they've moved forward. They've moved forward in the JP court. They've appealed it to this court. And so my client's been left with no choice but to evict them.
So are you saying that, am I understanding that there's no peel back from this to avoid having an eviction on the record?
I'm sorry, Your Honor, you cut out for a second.
Sorry about that. Are you indicating that there is no peel back, kind of peeling the pages back to enable an avoidance of an eviction on the record?
Not that I'm aware of, Your Honor. I'm not sure if there's a way that it would be confidential, but that I'm not aware of. I've only represented on the landlord side.
Okay. Alrighty. Is it Mr. Nelson, Ms. Goldsby?
Yes.
Ms. Goldsby, do you understand so far the questions and the responses?
Yes, and I just wanted to let the court know that we also applied for assistance, not necessarily was like the rent or anything, but to get us into another housing is what we did do, because they have that assistance program through the city of San Antonio.
Waiting to hear back on that.
And it's been a waiting game. I mean, I've been on the Section 8 list for 6 years now on that waiting list. And the wait time is ridiculous.
Your Honor, I also want the court to be aware that this is not a non-payment of rent case.
Oh, this is not because of non-payment of rent?
No, Your Honor. This This case is a little, it's very simple, but it's a little more, the facts are a bit different than a normal eviction case. Mr. Nelson is wrongfully in possession of the premises and has no right to occupy the property. Him and his co-occupants are trespassers who have never had a lease with my client and have never been given permission to occupy the property. They've never had to pay rent because simply there's just no lease. They were just discovered occupying the property in December of 2021.
We have a copy of the original rental agreement that allows other occupants to occupy the other rooms in this house. And under that, that's how we obtained the space here.
We were renting it through the
previous person that had the lease.
the previous tenant. Which we had no idea that, like according to the plaintiff, that they weren't supposed to be renting it out to anybody else. But there were multiple rooms in the house that were being rented out to other people. It's not on mute.
Okay, so if I understand, there's no rental, there's no lease agreement between Chris Nelson, Ms. Goldsby, and the property owner.
Yes, Your Honor.
No rents have been collected or paid
No.
to the property owner.
No, Your Honor.
Is there a property manager involved?
No, Your Honor. My client, he owns this residence just as a rental house and in Windcrest, and he regularly rents it out. He's not been able to. We are not sure who gave these people the permission to enter the property. At the end of the previous tenant's lease, he went to the property to go clean it up and get it ready for a new rental tenant, and he discovered the Nelsons in there. And so they've been asked to leave. They have not left. They've trashed the yard. They've left junk cars in the yard. They've been cited by the city of Windcrest. The city of Windcrest has urged my client to figure out how to move this along. My client was forced to file an eviction action in the Justice Court, which was appealed by Mr. Nelson and has resulted in today's hearing.
Peter was aware that we were staying here prior to that eviction. I actually had contact with Peter before that. And when we moved into this house, the yard was already trashed.
You realize you muted yourself?
Improvements to this house immensely. Most of the stuff that's been rectified is because it was pre us moving in, and I've done a lot of work. Peter did know about us living here before the eviction happened. We made it after the eviction. Made an agreement with Peter, a verbal agreement that I was going to fix up the property in exchange to be able to stay here.
You keep muting yourself.
Back on his word, thus, and that's why we have moved forward to today, because I complied with what he had asked, and he didn't. He backed out of it. So him saying that he didn't know that we were here, that's actually false. He did know that we were here.
Your Honor, that
Yes.
my client knew that they were there when they filed the eviction. That's the reason my client had to file an eviction. He didn't know that when they had moved in.
He knew that we were here a couple of months prior because there was a gas leak here that we had addressed and that he didn't fix, but I fixed. So he knew plenty of time before the eviction that we were here.
Your Honor, my client's here today if you would like him to testify to these claims as well. Simply put, the Nelsons have no right of possession at all. They're not paying rent. They haven't paid rent. They're just there and they refuse to leave.
We were paying rent to the previous contract holder. What she did with the rent, if she paid it or not, I don't know, but that's the agreement that we had with the previous contract holder. We agreed to pay rent after that eviction and try to continue to live in this house. That's when Peter backed out of his agreement with us.
Okay. Counsel, plaintiff, is there, if it's a mechanics of the pressure from the city of Windcrest to be able to take care of citations or avoid citations or take care of something, is there a way that that can be done? And is there a way that that can be done? The court can order the cooperation of the Nelsons to be able to do that.
I'm not sure, Your Honor. My client, none of the stuff in the yard belongs to him. It's there at some way by the Nelsons, but my client isn't able to move their stuff without their permission. And so the Nelsons would have to be the ones to clean it up and to remove their items. They've been told by police multiple times, City of Windcrest Police, and they've just not done it.
Your Honor, everything that's been asked of us by Windcrest, we have done. The only thing that is here, there's nothing in the yard. There's the trash has been taken care of. Everything has been taken care of that Windcrest had asked us to do. The only thing that is here is a vehicle that I am trying to get operable. They call it a junk vehicle, but in fact, it is not a junk vehicle. I just need to be able to obtain enough money to fix the one little minor thing that needs to be fixed on it, and otherwise it's an operable vehicle. Windcrest states that I can have the vehicle here in the driveway under a car cover, which it is here in the driveway under a car cover at this time. As far as everything else on the property, there is nothing else on the property that is in violation. Everything that they have asked us to do, we have done, and it is taken care of. So I don't understand why they're still saying that.
You're muted.
I can take pictures of the property and show you everything like right now. I can walk you around video feed and show you it's all been taken care of.
I appreciate all of this information. And the reason that I have asked these questions and have gathered this information is to be able to make a determination as to you need to be able to show me, if you wish for me to really give you consideration, whether to have an attorney present, to an attorney to represent you. If you're able to go ahead and be able to do that in a short enough time frame, if I were to consider that. So I'm considering the information I've gathered so far is to help me to determine whether it is necessary and fair to have give you some time to get an attorney, and it's not going to be much time if I do lean that way, or to proceed with the plaintiff allowing the hearing to go on and have you prove your cases, your positions. So that's all that has happened so far. I want to be clear. There has been I have not gathered any information regarding writ of possession or whoever possesses the property, okay? I have not gathered that information to be able to make that determination. It's just, I've gathered information whether to continue this case for you to be able to acquire representation. Do you understand?
Yes.
Yes.
Also, the attorney or analyst, plaintiff's attorney, has been have elicited some information from her to make sure that you understand your position, what is going, the consequences of the result of this hearing if I were to allow the hearing to go forward, and if it resulted in a judgment for the plaintiff, what would happen for the consequences that you will face. Do you understand that?
Yes.
Yes.
Okay. Now, I've heard enough to be able to make a determination one way or the other. The only thing is, I'm just going to ask you this. Mr. Nelson, Ms. Goldsby.
Yes.
Since November, or at least since I've got this case on the 19th of May, 2022, and now it's been at least a good 2 weeks, how can you convince me that you would be able to get an attorney in a short amount of time if I were to give you some time?
At this point, I mean, I would do anything to be able to maintain one, a roof over our children's heads, So I would be able to get a lawyer pretty quick because I want to make sure that our
Okay,
family isn't put out on
ma'am,
the street.
ma'am, this is just a matter of we're going to be able to get an attorney in this amount of time. We have the funds to be able to do that. And we can do that in this amount of time. That's what I need for you to be able to address.
If the court has any information on a place where we can call to,
Okay.
that's fine, we would go through
Let's
that.
not go there. Do you understand? This is, we have the funds to be able to hire an attorney. We can talk to an attorney tomorrow or such time and have an attorney available by Wednesday.
We would take that opportunity then.
Yes, we would, it would be, I'd get a hold of an attorney ASAP to make
Okay.
sure that we have one to represent us.
We would like to
Alrighty.
move off of the property. Don't get us wrong. We want to move off the property.
Let-
We can't afford this. So we are trying to get into another place. We just don't want to have our children on the streets at all. You know, we just
Let
try and-
me,
time.
let me go ahead and have you understand this clearly, okay? The plaintiff's attorney, attorney Ornelas has indicated what they're asking for is, one, take possession of the house, of the property, and two, attorney's fees.
Yes,
If I were to continue this case, for you to get an attorney to represent you, one, that increases the attorney's fees that they would be asking for. You understand that?
yes, I understand. We both understand that.
Uh, so you're stating, Mr. Nelson, Ms. Goldsby, that you would be able to acquire an attorney, given the time.
Yes,
Okay. All right. Again, Attorney Ornelas, just indulge the court momentarily. If the court were to continue this case, when is your next availability with your client?
Your Honor, I have next week open. You mentioned Wednesday. Wednesday works for me. If I haven't had a chance to talk to my client privately, but I can ask him if that works for him as well.
And I was just using that as a hypothetical. I may need to go ahead and kind of keep that open. Unfortunately, the court may not be available, but definitely the court would make an opportunity, be available, honestly, on the 13th. Would you like to go into a breakout room with your client at this time?
Yes, Your Honor.
Okay. Let's suspend the record and let that happen. And counsel, just so that you,
Oh, Your Honor, I think you're muted.
no, I'm not muted. I'm processing and thinking of my words. Just so that you appreciate the reason that the court may be considering and continuance is that there has been some issues that has been raised. And so therefore the court wishes to make sure that as far as the entire fairness of to be able to explore those issues with you. So if you would talk to your client and see, let's suspend the record and then for you to talk to your client and put you guys in a breakout room and consider the 13th while I double check with my court coordinator, make sure that those dates would be available. Okay?
Thank you, Your Honor.
Thank you. Let's go ahead and suspend the record at this time and place Attorney Ornelas in with. Thank you, Ms. Velez.
My pleasure.
Your Honor, the 13th works for us.
Yes, we'll get back on record for that. Let's get back on record on cause number 2022, C as in Charlie, V as in Victor, 01009. Peter Baratache, plaintiff versus Chris Nelson, and all other occupants as defendants. At the time that we suspended the record, I had asked the plaintiffs to check their schedule to see if the court can consider continuing this case, as the defendants have asked for continuance to be able to acquire an attorney. And the court has come upon some information that may be able to, that has aided the court in a determination to be able to consider that, even though despite the fact that this has been continued at least once by this court for that particular purpose. Attorney Ornelas, for plaintiff, you said that the 13th works for you?
Yes, Your Honor.
And excuse me, that is to be the 13th of June.
Yes, Your Honor, at any time.
Okay. Mr. Nelson?
Yes.
Ms. Goldsby?
Yes.
Understand that again, if I were to consider continuing the case till the 13th of June, will that give you sufficient time to hire an attorney?
That shouldn't be any problem.
Yeah, that's plenty of time. I think that's more than enough time.
So what that means is, if I, just to be clear, if I continue this case to give you the opportunity to hire an attorney, that means that you actually have from today, being the end of the day, to the 12th for your attorney to put in a notice of appearance in this case, or letter of representation, and then be present on the 13th of June for hearing.
Yes.
Okay, hang on 2 seconds. Okay. Plaintiffs, I hear you and I understand your position. I have heard and I understand and I have heard your interests in this matter. I have also listened and heard the defendants, Mr. Nelson, and I have heard you, Ms. Goldsby. The court is just because of the nature of this case, as you indicated, plaintiff, is a bit unusual. The court is going to grant you a continuance, Mr. Nelson and Ms. Goldsby, for the 13th. And 20 minutes have been announced on this case. You can appreciate the fact that each time I have given you more than 20 minutes, but we will resume this hearing at 3:30, a night for you to be available 3:30 on the 13th of June. That's Monday, the 13th of June at 3:30 in the afternoon. Your attorney must be present. Do you understand?
Yes, thank you very much.
Okay. All righty. Let me, before you get to thanking me too much, okay, let me make this very, very clear. When somebody owns something, as I'm sure that you're going to appreciate this, you guys have a vehicle that you say you own, correct?
Correct.
If you haven't given somebody permission to be in possession of that vehicle, you would want that vehicle returned to you as quickly as possible, correct?
Correct.
Yes, this is correct.
All righty. So that's the case here where Mr. Baratache is saying, hey, give me my house back, right? Right. And so it would be fair to him to get his house back as soon as possible, just as it would be fair to you to get your vehicle back as soon as possible, correct?
Correct.
Correct.
All right. So I know that you have indicated to the court a few things here. I'm going to give you an opportunity to have an attorney here to represent you. You're telling me that that should not be a problem if I continue this case to the 13th of June, 2022 at 3:30 p.m. Is that what you're indicating to me, that that would be a fair amount of time for you to be able to have an attorney present?
Absolutely, that'd be absolutely fair.
Yes, that's correct.
Okay. Then it would be reasonable for the court not to give you any more continuances. Would you agree to that?
Yes.
Yes, that is correct.
Okay, so then on the 13th at 3:30 on the 13th of June, 3:30 p.m., if you show up here without an attorney, you would not be asking the court to continue, correct? We can proceed with the hearing, the non-jury trial.
Correct.
Yes.
Okay, so make sure that you guys take a look at that. The attorney has indicated to you the law that she will be relying on, okay? That 510, section 510.13, right? Of the
Mhm.
Texas Code of Civil Procedure,
Correct.
okay? And so make sure that you are prepared and your attorney is available. I will grant you this one last continuance.
All right, thank you.
Thank you very much.
You understand that clearly, last continuance.
Yes.
We completely understand.
Plaintiff, if that's, I appreciate your generosity and consideration in this matter. And if that's okay, that 3:30 p.m. is okay with you?
Yes, Your Honor.
Okay. Again, the information that I acquired so far was just to help me to make that determination, since that was what was requested right out of the gate. And so Now, the defendants have indicated that they will be able to acquire an attorney and have the attorney present, and I'm thinking that would be the fairest thing to do.
Understood, Your Honor.
So thank you very much for your consideration and your patience.
Thank you, Your Honor.
All right, we'll be off record, and I'll see you guys on the 13th at 3:30.
Yes, Your Honor. Thank you. Have a great weekend.
You too. Thank you. Appreciate you.
Thank you.